Hello, and welcome to this pre-recorded ILTA panel entitled With Great Power Comes Great Responsibility, Regulating Generative AI. I'm your moderator, Kat Freeman, Legal Technology Innovation Solutions Analyst at Alston & Bird. I'm joined today by Abdi Aidid, Assistant Professor at the University of Toronto, Faculty of Law, and Katie Gardner, Partner in the Strategic Transactions and Licensing Group at Gunderson Detmer. Thank you both for being here today. I'd like to begin with some brief introductions before we get into our discussion. Katie, why don't you start us off?
Of course. Hi, Kat. Thank you for having me. So I'm as you mentioned, I'm a partner at Gunderson Detmer. We primarily work with venture-backed technology companies and the VCs that invest in them. So since everyone's been talking about AI for about a year plus, it's been a big part of my day-to-day practice.
Terrific. Thank you. Abdi.
Thanks, Kat, for having me as well, and I'm really excited to be here with you, Katie, on the panel. So I wear two hats, I would say. In this, I'm a law professor on the one hand, so I teach courses in privacy law and torts and civil procedure, and I'm a former commercial litigator. But at the same time, I'm also a legal technologist. I spent some years as the vice president of an AI startup called Blue Jay that built machine learning and GenAI tools for legal research and analysis. And so I both have, of course, the interest in ensuring that the profession and the doctrine is well respected and that my students have careers to go into that are richly rewarding and fulfilling. And I have some interest in some ideas in how we can deploy the stuff effectively. And so I come at the problem of AI with those two lenses.
Wonderful. Great. Let's appreciate it from you both. Let's go ahead and dive in. So in December, most of us all know the European Council and the European Parliament reached an agreement on the AI Act, setting their standards for regulation on AI systems deployed within the European market and across the EU. So while we could spend probably 2 or 3 sessions or more on this new act, I think for today, I just want to get your thoughts on what you think, if it makes sense for there to be some sort of global governance or single source of truth with respect to AI regulations, or should other countries outside of the EU model their regulations off of this new act? Katie, can you begin for us?
Yeah, so there definitely needs to be some global coordination when it comes to AI, particularly because of the potential existential risks with AI. I think are unlike anything else we've ever really faced before. I don't think it's possible for there to be one single source of truth on this. I mean, you can just look at the United States can even come up with, one federal privacy regulation. Like I can't imagine, every country, and countries have different, they have different goals, different values, different, things going on within their legal system and their culture. So it's not going to be possible for there to be a single, source of truth or a single kind of global regulation. But I think countries will align generally on many safety risks, and they already have started, doing that. And I know we're going to talk about it in a little bit on kind of the UK Safety Summit and what came out of that. And the EU approach, the EU is very kind of, the same thing they did with GDPR. They're kind of risk focused, and they take a broad view of this, and, other countries are going to take, different approaches.
Great. Thank you. Abdi, can you jump in on piggyback on any of that too?
Yeah, I agree that there can't be a single source of truth, but in many ways, the AI Act is a massive achievement. So number one, all the risks that AI can generate can happen across borders, right? This is not a contained sort of a risk profile. In the same way that things like data breaches or cyber attacks will have ramifications across borders, so too will the problems that are generated by AI's use. And so having a supranational institution be the first one to have meaningful, enforceable regulation, I think is a good model for cooperation between states. The other thing is, and this part of it can be underestimated, in the same way a lot of global privacy law was influenced by frameworks that were announced by the OECD in the 90s, this can really be a template for other countries that are thinking about ways to regulate. So even though countries will have different local flavors and different AI industries that they have to be concerned with regulating, things like the AI Act's description of risk tiers. I don't know if folks are aware, but the AI Act did something really interesting where it created this tiered system for how to think through AI risk. And it said, certain categories of technologies are going to be treated differently. Some are more inherently suspect than others. And they had this kind of threat level grade where it's something is, some have an unacceptable level of risk, others have a high level of risk, others have limited risk, and others have minimal risk systems. And each one of those categories attracts different regulatory scrutiny. That's the kind of thing that other countries maybe could consider adopting wholesale as a framework. And the more they do, and the more harmonization that we have around the language, probably the better we'll be in terms of trying to navigate the international scope of the problem. The other thing I will say about the single source of truth component is sort of the classic debate we have in regulation about how specific should we get, right? One of the major risks of comprehensive legislation of any kind is that you're making bets. You're basically saying it's our view that we have a sense of what's coming down the pipeline, right? And we're going to calibrate these rules in such a way where they're going to have enduring strength and enduring power regardless of what emerges. And that's not actually let me just say that's a more fraught way to regulate when you're thinking about new technologies, because we can't sit here and hope to anticipate what AI is going to look like in 5 years. So even that fruitful threat level kind of template I described could be rendered null and void if in 5 years, 10 years, 15 years, technology is yet more capable than we're currently anticipating. And so there's some downside risk to having that kind of comprehensive regulation. At the same time, just as creating source material for international regulation, it could be quite valuable.
Well, and I think, as you both know, and probably most people who will be watching this later know, with the EU Act, it was in draft form for a very long time. They had to pull it back when GenAI kind of sprouted out of the ether and go back through and revamp and draft and all of that. So I think that is that speaks to what you were talking about, Abdi.
Yeah,
Katie,
we have
anything
this
else?
kind of, yeah, I mean, we have this kind of, it's, maybe unprecedented, where you have the tension between the speed at which AI development is happening and the contrasting slow speed at which, legislatures are able to legislate. And so, there is kind of this risk both with the comprehensive and the very specific. And there are other jurisdictions that have taken really different approaches from the EU. Well, the EU has this kind of horizontal approach of we're going to be kind of neutral about everything, and the same kind of way it did with data protection. China has taken a more vertical approach of enacting regulations for very specific applications. That being said, I think it needed to already kind of update that with brand new regulations that covered different types of technology, but they were able to do it really quickly. So some of it is how, governments are going to be able to adapt to moving things through quickly to address kind of changes in the technology.
Well, let's stick with China there for a minute as you bring that up. They're obviously going to have more restricted regulations on AI and GenAI. Initial draft of their policies are include adherence to their censorship rules for chatbots. How do both of you think about how these kinds of policies from nations with similar sensibilities as China are going to affect AI developers and tech companies? Abdi, get us started here.
Yeah, I think you have to think about regulation as an expression of countries' values and the kinds of activity, behavior, outcomes they're willing to tolerate. And so in the context of a regime which has censorship rules, which has an interest in only allowing certain political narratives to proliferate, you're going to
Mhm.
see some manipulation of what the AI can do on the back end. So, for instance, developers of AI having to submit some of their products in advance for approval and regulating that through restrictive licensing regimes, ensuring things like compliance. We're talking about large language models, and large language models in generative AI have things to say. And so if you're already a country that's regulating speech, then there's a question about how much you're going to put your thumb on the scale in terms of what AI can say and how it expresses it. Now, the one thing I'll say, and this is for everyone out there, it's not as though we don't make political choices in the design of AI tools here, for instance. If a tool like ChatGPT was really trained on the sum total of all the information on the internet, and it was just allowed to speak freely, and we didn't put any strict parameters around it, if it's trained on the full internet, what does the internet sound like? It would be pretty racist and sexist and offer fringe political perspectives. And so there's ways in which we, in our societies on the back end, do actually manipulate the output, even choices that we make about tone. And, ChatGPT sounds like an earnest do-gooder. That was a decision that we made. And so in the same ways that we might put our thumb on the scale, you could imagine China putting its thumb on the scale, but towards more expressly political ends. The other component of it, of course, is that that's really the regulation of AI's output, but China's very permissive when it comes to what information can be used to inform and populate the AI models, right? There's less restrictive privacy regimes. And so you could imagine really fast developing, robust data sets that are then filtered on the back end, and that being sort of the regulatory approach.
So,
Yeah, I'll add a few points. I think there are aspects of the regulation that do align with, with what we're kind of seeing in other, Western countries, like watermarking, AI generated content and requirements for, transparency and requirements around accountability. Some things that I think are interesting is, what is in China's legislation that we've talked about, but hasn't made it in yet, which is a licensing requirement. That's something that, Sam Altman talked about a lot at, in the congressional hearings, and there could be a whole other kind of discussion on regulatory capture and lots of, questions about that. But, in China, AI developers are required to get a license from the government and submit kind of, get security assessments and stuff. And then the other thing that I think will be really challenging for AI developers, and Abdi was touching on this a little bit, is just the liability that developers have for the content and the requirements for things to be, truthful and accurate. AI models don't produce truthful and accurate content. If there's one thing we've learned, they don't discern truth. They just predict a pattern in speech, at least for language models. And so it would be really difficult, at least for, the US, in our promotion of innovation, to make tech companies, fully liable for all outputs of, LLMs. So we'll have to see how that unfolds and how that kind of affects companies that choose to operate in China.
And I will say, if I can,
yeah, please.
There's one of the big global challenges is how some of the lingering IP questions get resolved. So, for instance, you're probably all familiar that the legal status of scraped data is kind of up in the air in a lot of different jurisdictions. And so sometimes what will make the difference in whether a given country has a more permissive or more restrictive AI regulation regime is going to be how they treat scraped data, how the intellectual property laws treat scraped data, because that could be the great enabler of AI development. And so actually China, like the United States and a lot of Western countries, it's still the legal status of scraped data is still a little uncertain.
Right.
And I think that actually that's an example of a difference that might account for more regulatory variation than even the large, big political context.
Absolutely. Well, let's focus on the US then, since we've kind of brought them up a bit. They've got their Biden signed the US executive order on AI back in November. The US typically is more reactive than proactive when it comes to regulations in general. Talk to us about how the executive order is going to affect the AI sector. I think we've hit a few of those points, but Katie, where do you think the US is going to go from here?
Yeah, so I mean, the executive order, it's such a broad directive. I think it was the longest executive order ever issued, over 100 pages. So it's really comprehensive, and it kind of lays out all of, the administration's goals with respect to AI in terms of, encouraging responsible innovation and safety, while also minimizing kind of disruptions to the labor markets and positioning the U.S. as a leader. And it's prescriptive in a few areas, but it otherwise really leaves it up to government agencies to work out the details. So with very explicit deadlines when they need to kind of develop, further guidelines. So the prescriptive parts of the order really only affect very, very, the companies that are producing very large foundational models, and it puts, they had a kind of mathematical qualifier for what that meant. And my understanding was that it was, didn't cover any models that we know to be readily available on the market right now. Like, it was really talking about GPT-5 or these like very, very powerful models that will have to report to the government on, a number of different things about what they're doing for training and, results of red team testing and stuff like that. Otherwise, everything else, we kind of just have to stay tuned on what's going to come out of, all of the directives to, the agencies. So NIST is developing standards for red team testing. There's a review of what we should do about open source models and whether those, open source foundational models should have to make their weights available publicly. The Department of Commerce is working on guidelines for labeling AI generated content and watermarking. Both the PTO and the Copyright Office are going to publish guidance on inventorship and copyright issues. There's a call on Congress to look into a more comprehensive privacy law that will regulate AI. So there's a number of things that we're kind of in a wait and see mode to see what happens, but they should be readily forthcoming given the very strict, deadlines that were put in place.
Mm-hmm.
Terrific.
Yeah. Katie, you gave a really helpful overview and some of the details, so I'll take the chance to zoom out a little bit. I think that if you think about the executive order, it's pretty important in the history and trajectory of AI regulation, right? It's the White House talking about its sense of opportunities and risks, and starting to sort of try to motivate its various instruments to start to take it seriously and put pen to pad, so to speak, on actually operationalizing some of the principles. But you have to look at this in the context of a country that doesn't even have a comprehensive federal privacy law, right? This is at best going to translate into some form of principle-based regulation where the government articulates its aims, accountability, transparency, freedom from bias, whatever the principles are, and then is going to sort of leave it up to agencies in the first place, and then later industry, to develop its own sort of internal guidelines and standards around complying and achieving the aspirations of those principles. And that has important consequences, right? The nature of principles-based governance or regulation is that it passes on the kind of enforcement costs to the folks who are being regulated. So it says you have to have accountability in this measure, and then what do? You set up compliance departments, and you appoint a privacy officer, and you have you hire AI algorithm experts, and you opt into various voluntary codes, and you show how you're complying with NIST standards or whatever it may be. And that has implications for what the economy is going to look like on the other side of all of this, right? Because if you're a startup who's interested in AI right now, you're looking at a 100-page executive order, which is going to lead to who knows how robust the regulation is going to be, and it's going to be principles-based regulation. It's going to be the kind that's going to ask you to do things in advance, and not be highly specific about what the enforcement looks like. That's going to consolidate the advantage of the companies that can have those large departments, for example, who can absorb some of those costs, especially in an environment where it's still speculative, it's still uncertain. We have no sense of what enforcement is going to look like. We don't know what penalties are going to be. And so this is true, by the way, of the AI Act in the European Union as well. It's just a sense of, okay, there's a lot of uncertainty. There seems to be a lot of statements being made. Those might translate into rules, and it's on us. The onus is on us to make sense of a lot of it in the meantime. And so I can imagine lower budget organizations being intimidated out of the process because that certainty isn't there yet. And that's something just to keep in the back of your mind as we evaluate the various offerings.
Fantastic. Thank you. We don't have a ton of time left, and I do want to, as Katie mentioned before, I want to talk a little bit about the AI Safety Summit that was held late last year in London. This was a 2-day event hosted by the UK, and the countries that attended, they all agreed to the Bletchley Declaration on AI safety, which went on to recognize a shared consensus on the opportunities and risks of AI, and more collaboration for the future. If you could each briefly kind of talk about if you followed this summit and kind of what other discussions and outcomes came out of it. And if you, and also just finally, if you want to add any other points of what you see going forward for the AI regulation globally and in the US specifically too, that would be great. Thanks. Katie, get us started, please.
Yeah, so I'll tell you what I followed at the time was, it followed so closely in time with the US executive order. And so I think a lot of what I was seeing and hearing was really the contrast between, okay, the executive order is a 100+ page document. It was really evident that there had been a lot of thought put into it, and it was not just put together by Congress. There was a lot of, all of the output from all of those open sessions and closed sessions that they had with, industry experts. They really did kind of think about all of the risks and try to put in place like this very detailed plan. And the Bletchley Declaration, well, I think it was meaningful in that, you have the US and China and the EU and the UK and many other countries that we think of as having, potentially divergent views on this, collectively coming together and agreeing to kind of, some shared understanding on some of these existential risks and things that we need to do going forward. It wasn't, I don't think it's actionable as people were seeing at the same time out of the executive order. So I think some people were maybe a little bit underwhelmed by it, but I think it is still meaningful because we do need to continue having these discussions and cooperation and coordination, exactly kind of how we started this session and what we were talking about. And there are plans for, another session, I think, in a couple months. And or actually, I think there's going to be 2 in 2024, one hosted by South Korea, another by France. So we will kind of see what comes out of those. But it's just going to take kind of more time and more coordination and more discussions for countries to align on how there needs to be collaboration.
Yeah, I agree with that. It was a pretty thin declaration as far as I mean, if we all said, okay, let's implement the Bletchley Declaration, we wouldn't exactly know what to do right now, because it amounts to a forceful statement about how we kind of like AI, but we're scared about it, right? So I think what's interesting about it is sort of what it means as a historical document, because you have this 2-day summit that was attended by the US, the European Union, China, I mean, the Kingdom of Saudi Arabia, Rwanda, like all these countries that have their own distinct interest in AI, and those interests could be well divergent, that managed to agree on something. And by the way, it's easy to say it's a 2-day summit. They had a pre-summit report. There was all this lead-up work, and that's also available online. But if you recognize it for what it is in that case, then you start to look at the declaration differently and see that they actually have specific agreement on some things that, and those could be areas for future collaboration. So for example, the declaration talks about they're especially concerned about the risks of AI in cybersecurity, biotechnology, and disinformation, right? And so I don't know, maybe they couldn't forge consensus on concerns around AI in the judiciary. Maybe they couldn't form consensus around concerns around AI in financial services. But we know biotech, we know cybersecurity, and we know disinformation. And so maybe there's opportunity for discrete collaboration on those areas, if those are some areas that we can begin to have sort of like domain-specific international coordination about. That's something that could come out of this, I think, which is interesting. Beyond that, I think that now the question is going to be, can the follow-up summit go one level deeper and start to talk about, well, what are the what are the vehicles that we need to actively work on this stuff together? You know, in the same way that you know, G7 summits, formerly G8 or G20 summits, will create institutions and evaluation mechanisms and monitoring frameworks. Can the next summit give us something that we can point to and evaluate the effectiveness of, and can do some work that happens between the summits, as opposed to waiting for this like flashpoint of activity.
Right. And it sounds like we've all kind of, between China, the EU, US, and other countries, we're putting our frameworks in and getting sort of that laid out so we can dig in for the real work of how we actually truly regulate all of this going forward.
Absolutely.
Abdi, please.
No, I was just agreeing with you.
Yeah, okay. Katie, anything else to add on your end?
No, I don't think so. I think Abdi
Probably not in the time we have.
pretty well.
Well, I want to thank you both so much for giving your time today. And I hope everyone who watches this later will get as much insight into this ever-changing topic as I have today. Really appreciate your time. Thank you.
Thanks so much, Kat.
Thank you.